This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
Yes. Before Lordship looks at it, well, my first point is this. Once a law of the land is declared by the Honorable Supreme Court, what is the effect of it? Keeping in mind two dates. Date number 1, September 2022, the writ petition was filed. Precise date is 12th of September 22, the writ petition was filed. And the Honorable Single Judge's order is 12th of May 23. The consistent view of the Honorable Supreme Courts, as I have brought 3 settled principle, when a writ petition is filed, the litigators, everyone's right is crystallized the day the litigation is filed. Precise citation on that is rights of the 2003 1 SCC 726, paragraph 7. 2003 1 SCC 726, paragraph 7. The short portion. Having heard the learned counsel for the appellant as also the learned counsel for the state and the private respondents, we are satisfied that the appeal deserves to be allowed. The ordinary rule of litigation is that the rights of the parties stand crystallized on the date of commencement of litigation. Lordship may kindly. And the right to relief should be decided by reference to the date on which the petitioner entered the portals of the court. A petitioner, though entitled to relief in law, may yet be denied relief in equity because of subsequent or intervening events. That is the events between the commencement of the litigations and the date of decision. The rest portions I need not. I am only on the point of crystallization of the right of the writ petitioner in September 2022. Now this point, as I said, it is a very consistent view. It is our court. It was by Honorable Justice Dipankar Datta's judgment, sitting in the division bench, 2018 SCC Online, Calcutta, 12185. 2018 SCC Online, Calcutta, 12185, paragraph 5. This is even tweaks little bit, that it is not only from the date of crystallizations, one may not even get the relief if in the intervening period anything happens. Paragraph 5. Law is well settled that although ordinarily right to relief relates back to the date of institution of the proceedings, that is crystallization in September 22, the remedy of a writ being discretionary, in an appropriate case relief may be declined if during the pendency of the proceedings before the writ court there is a change of law which makes the relief incapable of being granted. The same thing has also been echoed by the Honorable Supreme Court. This is the last judgment on this. 2020 9 SCC, page 1. 2020 9 SCC, page 1, paragraph 101. This on the point, if there is a change of law, an appeal is pending, there is a requirement of take note of that change by the Honorable Appellate Court.
Yes.
Paragraph 101, well, this is a quote from the another judgment. In Lokhinarayan Gui versus such and such, it was laid down that change in law during the pendency of the appeal has to be taken into consideration. Thus, that a change in law during the pendency of an appeal has to be taken, practically the same thing. Lordship may keep that. Thereafter, just under 10. If the new law speaks in language which expressly or be clear, interdependent, takes in event pending matters, the court of trial as well as the court of appeal must have regard to an intention so expressed, and the court of appeal may give effect to such a law even after the judgment of the court of first instance. My first fundamental point is this: 2016 rule 6.2 and 6.3 has been interpreted by the Honorable Supreme Court in April 2025 in two clear categories. Before saying anything, I will show three paragraphs. Thereafter, I would say what, my lord, what is my submission. Kindly take, my lord. Kindly take my note.
Yes. Which judgment you are?
Yes, my lord.
Note.
Note. The note contains, my lord, the formulation which is directly taken from the Honorable Supreme Courts.
Yes.
Yes, my lord, I say that 2025, kindly see Roman 1, two categories have been formed by this judgment. True, after the single bench judgment, correct. That is, one is just an untrained candidate who are the writ petitioners and who could not get themselves trained by April 2019, which is one of the most important dates. And Lordship may straightway kindly come to paragraph 26. Three paragraphs I would be relying, two for us and one for them. Plus 26 of 2025, Lordship has copy of the judgment. I have extra copies also.
2025.
The last question I gave, but there is no difficulty. But I brought the another extra copies. Lordship need not waste any time. There are copies. देखो 25 SCC online SC 722 722 Justice Gawai. Yes. Well, before placing the judgment, my respectful submission is this: by this judgment, which is, my lord, which is a law under Article 141 applicable to, as the Honorable Supreme Court held, for more than 12 lakhs pan India, a window was created and recognized by the Honorable Supreme Court having three fundamental pillars of the window. If anyone fulfills the three conditions of the window, as I said metaphorically, he becomes a butterfly. Well, I am using the caterpillar as an untrained and butterfly as a trained. The Honorable Supreme Court's law.
Mr. Dhar, what is the point you are arguing? Reference to what? All right, crystallized on the date of filing writ petition. Then
Yes.
what is your argument?
My argument is this: by virtue of the Supreme Court judgment, once the conditions are fulfilled by April 2019, that is pre-filing of the writ petition.
Where do you find that date? April 2000?
Yes, that date can be found paragraph 26.
Of what? Paragraph 26 of?
Date is one pillar of the window.
Paragraph 20.
Paragraph 26 of Kaushik.
What you are arguing? What
I am arguing this.
Go to metaphorical examples. Tell us what you are arguing.
My submission is this: the basic premise of the learned single judge was, we are untrained
Yes.
and
Some
others are trained.
Yes.
So around 10,000 trained.
Trained is not involved in.
Yes, I'm saying. So we are untrained.
You're untrained.
At the time of recruitment. That was the premise. And therefore, no protection to us because we were untrained. That's the premise of the judgment. Because we were untrained and because corruption happened as perceived by the Honorable Single Judge, therefore untrained candidates do not deserve any justice or equity. Their termination is the right course of action. And following action, what should be done? That was the basic premise. The judgment of the Honorable Single Judge has two categories. I am not touching the trained, clearly said. Irrespective of the fact that interview, taste, whatever, though I have all my independent points that this is just a perception, not correct. Irrespective of the fact, everything was in the similar manner. But because at the time of recruitment, under Rule 6.3, I was an untrained candidate.
Yes.
Admittedly.
Yes.
So that was the premise of the Honorable Single Judge to make a distinction between trained and untrained.
How does that affect you?
Yes. If I put
you are also untrained people.
I am untrained,
yes,
but I am no more untrained after 19th April 2019. That is the law of the land declared by the Honorable Supreme Court after setting aside the judgment of our court.
It's not the ground of the cancellation of the appointment.
Exactly. That's my point.
Why you are arguing that?
I am arguing because the writ petition was not filed.
Petition said that I am untrained.
Yes.
You are untrained.
Yes.
You have been favorably dealt with by the board.
But when the writ petition is saying so,
that was in September 2020.
Yes,
now whatever right crystallized in your favor, we are not on that. You are asking us to examine whether the direction for cancellation was justified.
Absolutely. Can you look at this way?
So please make it within those parameters.
I am coming to that. Can you see that? Well, this is most likely, unless I am missing, either I am missing completely, or there is such a fundamental point which has been missed completely by the. Allow me to reframe it. All I am saying, by virtue of the Honorable Supreme Court judgment, which is the law of the land, can you forget it that I understand this law of the land was declared in April 25, but Lordship is hearing today. Lordships may not ignore this judgment. And this judgment, Supreme Court clearly held that by 19th April, I ceased to be an untrained. I was surprised when I read it. That was my first reaction. I know I'm doing something like adventuring because this point was never been there. Of course, it was never been there. But
now, then what is the analogy? Then after April, what is your character now?
Yes. After April, if I fulfill those three conditions, the condition number one, that I have to be in service by August 2017. That's the Honorable Supreme Court held. Condition number two, during service, I have to complete that through NIOS only. And third condition is, I have to complete that course by 19th of April. And thereafter, the Honorable Supreme Court said, anybody who is not fulfilling or fulfilling only one condition of fulfilling after April 19, he will not get this benefit. Effect is, after April 19, because of the fulfillment of these three conditions, declaration of the Honorable Supreme Court is, you become at par with the trained. That is what Rule 6.3 of ours. Or I would have faced the dismissal. Now this declaration.
Have they made this point in their writ petition?
No, why they will make? They will not make it. I say that, kindly visualize this way. They filed the writ petition in September 2022. Now in September 2022,
your contention is by the cutoff date, I have now become a trained candidate. I have been appointed. Untrained cannot disturb my appointment. Because now at this juncture, I am trained. That is your argument.
Yes, plus by the same judgment, the Honorable Single Judge has said, I am not touching trained candidates who were trained at the time of recruitment.
Yes.
Now,
all right, your argument is by the cutoff date, I have become trained. You cannot challenge my appointed now in this course, in these facts.
By telling me that you are an untrained, all I am trying to say that had the writ petition being filed before myself become,
paragraph you're
yes,
showing.
paragraph 26, 3 paragraphs. Kindly see 26 first.
Yes.
Well, this is, Lordship has got 26.
Yes.
It can thus be seen that this court observed that since the time gap between the direction issued by the central government and 31st March 19 was only about 18 months, the period of the course was reduced from 2 years to 18 months. It can further be seen that this court recorded that around 12 lakhs, such and such, in-service elementary, in fact, we also fall under 12 lakh, elementary teachers had registered and made payment on the NIOS portal as on 30th September 17. Not only that, but this court also observed that the NCT recognition order dated 22nd September 17 was, kindly mark this, only for those untrained in-service teachers in governmental aided, unaided private schools who were appointed or not before this condition, 10th August 17. So anybody after 10th August, no. Pertinently, this court observed that the entire scheme was for the purpose of providing a window to the in-service teachers in as much as unless they would have acquired requisite qualifications prior to 1st April 19, they could not have continued to remain in service and would have faced dismissal. Kindly thereafter see 33. Or before 33, sorry, paragraph 28, last sentence. Writ petition would be attracted under that. Because there is the direction by the Honorable Single Judge, hold another examinations, giving them time to do the training, which is completely contrary to 28. 28 last sentence. Any other candidate who was not in service as on 10th August 17, that is writ petitioners, cannot be considered to be at par with the 2 years DLED. Kindly come to 33 thereafter. As observed herein before, as observed herein before, it is clear that the judgment of this court in the case of Jaivi Singh unequivocally held that the entire scheme emanating from the NCT recognition order dated such and such was for the purpose of providing a window to the in-service teachers in as much as unless they would have acquired requisite qualification prior to April 2019, they would not have continued to remain in service and would have faced dismissal from service. As such, this is the condition. Any teacher who was in service as on 10th August 17 and who acquired the qualification of DLED by way of 18 months program through NIOS prior to 1st April 19 is a valid diploma holder and at par with any other teacher who has been completed the 2 years DLED program. My respectful submission is this. Had the writ petition been filed prior to 19, no difficulty.
Have you taken? You couldn't have taken this ground in the appeal.
But that is,
You are now going beyond that.
Your Lordship,
new points.
yes, Your Lordship,
This is not the subject. You have not taken this ground in the appeal.
may I say this? May I say this? Would Your Lordship genuinely think that I should not take this point? Then I will not say any single word.
That is choice is up to you, Mr. Dhar.
Well,
You are arguing something
well,
which
a
is
law-
not there.
May I say
It's
this?
not even there in your appeal.
No, that is there. May I say this? May I say this?
Where is it? Show us
But-
one ground that
Lord-
you had a premeditation that Supreme Court
Kindly-
in future years will decide.
Kindly allow this. Kindly allow.
Unnecessarily elongating the issue.
This is not unnecessary.
This is because that is one say you are saying your writ petitioners have not pleaded anything and they are taking this.
May I say?
Now you are saying that no, though I have not pleaded, I will
No,
take this.
no. Kindly allow me to say what I'm.
We have allowed you, come to the next point.
But I will come. But I have not finished this point. Lordship,
We understood
but
it.
I am not a
have
joined the
understood
practice for 1 year and I will take all the irrational things. Lordship is dealing with the lives of about 2 lakhs persons.
Please don't remind us of our duty and obligation.
So kindly.
We have put your question, you have failed to answer that.
The
But
question.
still, we have heard you on that point. You proceed to your next point.
I'm answering to Lordship's query. Lordship's query whether I have taken this point or not. Kindly see the date of the judgment. It was of April 25.
You could not have taken.
So therefore, we don't have a time machine.
So then why you
We were not
taking
even
these
parties.
points?
Kindly look at this way. No, Lordship, this is unfair. I was not made as a party. I had to go before the Honorable Supreme Court. Supreme Court directed that all contentions have to be made. In the meantime, Supreme Court declared a law. Lordship do not want to see it. Can this be a law? Can this be a law?
What we are doing?
My interpretation, kindly see, my interpretation may be wrong, but to tell me, go back to the time machine, this judgment was delivered in April. I am trying to get the benefit of the judgment.
Don't misquote us.
Yes.
This point you raised on the earlier occasion also.
This-
He said, Mr.
Yes.
Dhot,
Yes.
please restrict yourself on
Yes.
the basis of the materials which are there. You insisted that I should put this point. You have put your point. We have taken note. Finished. Come to the next.
I have taken this point in a sense that under 6, can you take the rule, my lord? Can you take the rule itself? Because this is not that something new has come up by the Supreme Court. It was there very much part and parcel of the rule. Every time, my endeavor is this. Kindly, my lord, I may not be able to, my lord, express myself. But my endeavor is this, that once a litigation is filed, then rights of the litigators is of that date itself, and that is 22. And the window created by the Supreme Court based on the NCT several orders, that window is finished by 19. Now, right before the learned single bench, this judgment was not there because there was a contrary view in present. But today, all over India, every teacher who are appointed and fulfilling these 3 conditions, they are treated at par because of paragraph 33.
We understood you.
And
What more you have to
now,
do?
Lordship, may kindly look at this. Kindly see this. Kindly take, my lord, the copy of the rule possibly with your lordship. Kindly take the rule. Rule 6.2 and 6.3. Copy of rule.
That has to be done within 2 years.
Because that this is directly recognition of rule 6.3.
Yes.
Because
By rule 6.3, they have completed, they have those appointed, they have completed the check.
but we did not have any seal of the Honorable Supreme Court. All I'm trying to say that we did not have a seal of the Honorable Supreme Court of at par. Now that seal came in 2025, which had a retrospective effect in understanding of the law before a Honorable Division Bench, when this Honorable Division Bench is deciding. This is my point. My first 3 judgments was that this is during pendency.
Yes.
This, well, copy of the rule, Lordship might be having this.
It is out.
2016.
Latest, I think, 8 years ago.
Well, I have a separate copy also. Lordship might have marked.
Yes. Yes.
Yes, Lordship, kindly see 6.2. I'm not reading entirely because it has been read only the last line. Read with relaxed qualification issued by the ministry from time to time and past that period. So, and 6.3, that 2 years.
Yes.
So, I will conclude this point by after saying this. So, Lordship, may kindly think this, that there was an existence of contingent condition to be fulfilled under 6.3. I have fulfilled by April 19. Having fulfilled by April 19, there I use my metaphor, I have become a butterfly, no more a caterpillar. But the single judge has treated me as a caterpillar.
Yes.
That is wrong because of paragraph, Lordship, kindly take the paragraph 22 of the Honorable Single Judge's order. It goes directly contrary to this, the law declared by the Supreme Court. Kindly take paragraph 22 at page 624 in the paper book.
Yes, read it. Third.
Paragraph 22 runs completely contrary to paragraph 28 of Kaushik. Because paragraph 28, the Honorable Supreme Court had held, this is only available subject to fulfillment of 3 conditions. But here the learned single judge gives a separate condition. Kindly look at, the board shall immediately arrange for a recruitment exercise for candidates who were untrained at the time of recruitment, including candidates who have obtained training qualification in the meantime, within a period of 3 months from date. This is totally going contrary. From date only for the candidates who participated in 16. Kindly have a look at paragraph 28 of Kaushik. So therefore, learned single judge gives time, even 3 months more, much after 19.
Yes.
Kindly take the one sentence of paragraph 28. The last sentence of 28.
Yes.
Any other candidate who was not in service, that's a writ petitioner, on 10th August 17 cannot be considered to be at par with the 2 years DLED. So therefore, window was there, 3 conditions were there, it is sealed. Nobody after April 19 cannot make himself trained. Not possible as long as this judgment stands. I am over on first point. My second point. If I use this word, the Honorable Single Judge completely ignored the statutory word natural in Rule 2C of teaching test. Kindly see 2C. "2C is never a test."
Yes.
Well, my second point is the Honorable Single Judge completely ignored a particular word in the definition of 2C, which changes the entire color of this. Kindly see 2C. 2C never says about the aptitude test. It's a natural. First Lordship, take it.
Yes.
Well, a definition is aptitude test means a test, kindly mark, to assess natural teaching ability of a candidate. It is not a separate test at all. Kindly take the examples of, we often have in our college, the extempo debate competitions, where the judges take a decisions based on assessment of overall presentations, content, maybe oratory. So assessment has to be under 2 categories: viva voce and the natural ability of a candidate. Sorry, natural teaching ability. Well, I was trying to understand what does it mean of the natural, because what's the difference between? Lordship kindly takes the blacks. Lordship may take us a very, very common understanding while Lordship hears out the matter from the advocates. There are content, there are laws. Lordship looks into that. Simultaneously, Lordship also sees, I think this is a very, 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 as a Homo sapiens, we get that. The natural ability of the person, whether to communicate or not. So my submission is, it should be one test. In the test, there would be questions. While the interviewee answering the question, the interviewer would, in addition to the correctness of content, also assess, does he have a natural ability to teach? That's what 2C says. Lordship, may kindly have a look at the definition of this. In black.
Did your interviewers understand this?
Well, I will satisfy your Lordship.
Tested by persons who are not even qualified to understand that much of
Well, they understood. Well, one of the examples, Lordship may be shocked. Lordship may be
making an argument. Now you kindly go through the definition, and definition will show that it is not a segregated test. Interview and aptitude was tested. It is only the nature of question which was put is to be different.
It is to be segregated assessment. Kindly visualize. I don't say that there should not be any test for natural ability. I don't say so.
We are asking you, was this done?
It was done. I will show from the evidence also.
It was.
Lordship would be surprised. On every fact, I shall be satisfying your Lordship's conscience. I am not going to take any technical points. Kaushik was, of course, maybe a technical point. But most likely, I would be able to persuade your Lordships that on fact.
What is your argument to that? That interview and aptitude have to be taken in a composite manner?
I say this. How a natural ability can be assessed? Kindly visualize.
You tell us.
Yes. I say that if a test is exclusively for a test for judging natural ability, then you kill the naturality of it. Kindly think over it. Lordships are testing the lawyers. Whether Lordships require a separate test for the lawyers to understand the natural ability to communicate, or that is in the process in
Mr. Dhar, primary teacher applicants, they will understand so much. Your interviewers will answer
this is nothing to do.
Asking us to go into the issue, the manner in which you understand the definition.
I'm saying that
it's unfortunate.
No, I'm not.
You are bringing in points which your board interviewers did not have that amount of intelligence, so to say, as you are arguing in this matter.
No.
You are just because you are the arguing counsel.
No.
Whichever things you
they understood it. They understood it correctly, but they were not able to communicate it. They may not be able to say it as I am saying.
So you cannot communicate afresh on their part.
No, I will not communicate.
Please don't do it. You restrict yourself on the ground of challenge.
I am restricting, my lord. I am not making submissions which are not relevant. Kindly visualize this. Lordship has seen in the judgment anywhere that word natural has been used by the Honorable Single Judge.
Don't do post question to us. You make your argument.
But I say that, sorry, that was my mistake. Sorry, extremely sorry. But the Honorable Single Judge, sometimes I'm so sorry, I shouldn't have. But the Honorable Single Judge in the entire judgment has not used the very definition of aptitude test. Two things are different. Assessment of aptitude test not done is one thing. An aptitude test has to be a completely separate test altogether is a different thing.
So you say they are intermingled.
Yes, because I also give an answer. Because preservation of the naturality. My lord, when someone is answering questions, kindly look at this way, my lord. There has to be certain amount of subjectiveness, or I can use arbitrariness. Subjectiveness is a better word. When a question is asked on geography, on history, on English, on anything else, if the answer happened to be the same, like a quiz contest, but how that answer is given, if the persons who are taking the interview, if they understand it, that's the natural ability. They would be the best person to assess it. Therefore, there has to be an assessment. Absolutely right, the Honorable Single Judge on that. But to say that, no, there should be a separate test altogether, like a separate day, separate test, that is incorrect.
That the court has not said. Separate day it should be held, it has not.
Court has said there was no aptitude test.
That is one thing of it. That aptitude has to be taken in a separate date. This was never the picture.
But that the Lordship, kindly take it.
Judge proceeded on the basis that when there are two faculties of mark giving,
Lordship may be shocked in the process that the Honorable Single Judge has proceeded. Kindly come to page 615. A person was called, his English was not good, and the judge terminated his service there and there by a judicial order. At least in my last 28 years of practice, I have never ever come across this. Do I need to spend one sentence to say that this is so unjust? A person who is not a petitioner, who is not a candidate, who is nobody, he is called, his English was poor. So how many of us would actually lose our license?
Not the ground of challenge. That is not the ground of challenge.
Need not be. But that's the basis of 615.
Don't go into the conduct and the manner it was done.
I am not going. Kindly come to 600.
Well, you point out the action, all right.
Yes.
Please don't go.
But that has been taken note of. Kindly take it.
The court had been unreasonable according to you. Finished.
No, but if it is,
person doesn't know English. If he said that, go, I am terminating your.
If I finish in that way, then I actually finish. I am trying to survive.
What?
Kindly have some mercy also on us. There are two sides. There are both sides of a story. Possible that my story is not good enough.
Yes.
Kindly take 650.
It is okay.
Kindly take two notes. There were 700 interviewers.
700 interviewers.
Total, approximately.
Where did you get that figure from?
I don't have, but I don't think.
Nowhere it is there. Yes.
But there has to be a number. But Lordship, for understanding that 30 of the.
Which page you are referring? Page?
Page 615. 30% were called.
650.
Yes.
Yes.
Now, Lordship may kindly first mark, I have calculated who said what, and what I have found out of 30, going by the exactly recording of the judge, out of 30, 13 said no aptitude test. Kindly take number 1. Did he say that there was no assessment of the aptitude, natural ability? He didn't say so. He said there was no aptitude test because any common persons will understand aptitude test itself as if a separate test. So out of 30, 13% said no aptitude test. Kindly come to serial number 16. That's the reason I said this. Serial number 16 was Mr. Tushar Kanti Das, the unfortunate gentleman whose English was poor. By a judicial order, he lost his service. And that is not, and that is page 616. Can you see? The recording is evidence on the real question was not taken for special reason. Most likely, Lordship will kindly take my serial number 16. Tushar Kanti Das, what is the evidence on the real question was not taken for special reason. Lordship has seen that. Now kindly see what is the reason, page 537.
Yes.
The reason was this teacher understands very little. He is a teacher of a secondary school. Kindly see, I find him wholly unfit for teaching job in a school. He has clearly stated that he does not know English. I do not know how he will develop teaching ability. Incidentally, he was a game teacher. Ability to teach a student. Hence, I recommend the West Bengal Board of Secondary Education to terminate the job of the deponent forthwith. If I have to spend one more sentence on this to say this is injustice, I feel extremely sad about it. A witness, no way connected with the case, was not able to, in fact, I got the judgments by the Honorable Supreme Court saying if somebody is not good in English, do not deprecate that. We are living in a federal structure. There are villages. Not everyone gets an urban education. And there we have,
What you are meaning to say, Mr.
I am meaning to say that
the judge was unreasonable. What is your argument, sir?
do I have to, I say this. Yes, I borrow your lordship's word.
So if you say that this is an unreasonability, all right.
There is an unreasonability of a,
If for unreasonability you go for a predisposition,
no.
then it becomes a bit.
May I say what I say? Can you see? I say that on a scale of unreasonability of 0 to 1000, it falls under category of 900 and plus. Had it been an unreasonableness of 0 to 100, possibly I would have ignored it.
Understand the backdrop in which it is being.
No, he is not a candidate. He is not a corp person.
How does that affect you?
It affects. Kindly come to 615.
Somebody has given me less numbers in the examination. If that is challenged.
No.
If the principal of the school is sent for termination, what effect does it have?
May I explain how? Affectation is this. I decide the rules. I decide what should be the question. I don't read to see. I forget about the naturality of the test. So I ask a question, was there an aptitude test? So that is a fundamentally flawed question.
Very good. That will be your argument.
Now while I do...
fundamentally flawed questions were put to the interviewers. Finished.
Well, it is...
Kindly see the conduct of the judge. Why for that reason, one word, person terminated, not knowing English is not a requirement. I will cite Supreme Court judgment so that is beyond the scope and ambit of this matter. Sorry, but we are expressing ourselves.
No, that is the best way to express. Well,
it is not that we are shunning you out from the.
No, I understand. Well, I understand. There is absolutely no difficulty. I say this.
Yes.
That kindly look at this and kindly connect the dots.
Citing these problems in.
Yes, I'm connecting. There is
your argument?
Yes. My argument is this: 30 persons were called. Now, out of 30, it is only 13 said no aptitude test. What about the 17? Why the Honorable Single Judge did not say anything about the 17? So therefore, first I take it from 700. It is my own sample. It is my own question. And it is also my own angle and perception I am putting into the whole perspective. And say this is a corruption. I could have understood that the Honorable Single Judge said out of 30, 17 of them. Kindly look at their deposition. I have read each of the depositions.
Yes.
This is, where is the deposition? 615. Yes. Kindly see the serial number 2. Aptitude test was taken. Why the Honorable Single Judge, my question is this, did not give any reliance on serial number 2? Even going by the pure mathematics also, he is ignoring the majority. Kindly see serial number 4. Aptitude test was taken, but no separate question for interview or aptitude test. Fundamentally, what I am trying to say, one interview, in the interview assessment of aptitude, natural ability and nothing else, not a separate test. Kindly see serial number 6, aptitude test was taken. Kindly see serial number 10, aptitude test was taken, but no guideline was there. Then serial number 12, interview was for 10 marks, but said aptitude was taken. Serial number 14, aptitude test was taken, no guidelines were given. Serial number 16, that gentleman who lost service.
Come to rule 4, sub rule 5.
Yes.
With the approval, got it?
Yes, I'm coming.
Place it.
Rule 4, sub
rule 5. Any such modality or procedure or guideline was framed?
Well, here, Lordship is referring with prior approval of the state government.
The board shall have the following power
to lay down the modalities, procedures or guidelines as the case may be.
Or any modalities laid down. Do you know that?
But here I have submission. Kindly consider.
No, we are asking, do you know any such modality has been laid down?
From the evidence I find no.
We are not on that. We are saying, yes, any such modality was there.
Well, there was a guideline sent to the interviewers, those who are interviewed from the board.
Where is that? That is not on record.
Not on record. Not on record. But there is I've seen I can show it to a lordship.
All right.
But Lordship may kindly, but I have one Lordship may kindly consider this. I thought it has. If someone has to decide the natural ability, is it not very intangible?
Yes.
Because that would depend on the emotional quotient of the persons. Because how, can you visualize that, how a person would be able to teach in a natural way? Meaning thereby, how one person's possibly, this is purely my subjective understanding, whose sayings would be more like a storyteller, so that children would actually listen, because storytelling is the best way of absorbing. That even the science also recognizes that. So,
yes.
Can there be any guideline to assess that? Answer could be yes, answer could be no. But having participated, I don't need to say any sentence on that, in 2016, in 2022 saying there was no guideline for that. But learned judge, the order is based on, not on that. Learned judge, there was no aptitude test. So, my first submission is, even the evidence of the honorable judge, majority said there was aptitude test, and those who did say there was no aptitude test, it is my explanations, they understood aptitude it to be a separate test.
All right.
So for me, of a question possibly should have been whether there was any assessment. But this is
assessment of natural ability.
Yes. Which I feel, I don't know, I tried also, that if someone tells me, how do you assess about any of your juniors, whether he has a natural ability to express better? How do I assess it? I assess in my everyday life, when I talk to him, whatever I do, because that's a very intangible thing. Lordships also do that. Somebody might have a good understanding of law, but lordships, in a very intangible process, assess the natural ability of someone who tells whatever thing.
Yes.
Well, my third point. Huge absurd marking.
Pardon?
Huge absurd marking.
You put it here.
Yes, that is in the note also. I'm coming to.
Yes.
This is at page 3. Well, before I say anything on that, kindly visualize this. I believe, my lord, in this courtroom now, approximately, I don't know, maybe 100 persons are there. It could be huge, because in every matter, not so many persons remain. But the same persons in Eden Gardens, it's not huge, it's negligible. So what the honorable judge has done, he has expressed his perception without the perspective. I have taken the exact figures of the honorable judge. Honorable judge's finding is about 5,000 persons got more marks in the orally and they were not good in academics. I will give the figures.
5,000.
I have exactly calculated. I found it was
in the order.
First paragraph.
In paragraph 14. Lordship, kindly come to paragraph 14.
Yes.
May I just place this part? Now I give example of a candidate before giving a table prepared from the document on record.
They are 33 persons.
Yes.
53 persons, sorry.
No, I don't take 53. I take the full. These figures have been taken from page 238 to 358. And I have calculated the entire figure becomes entire examination 5,216 persons were academically poor. That's from record. Lordship will get it from page 238 because the Honorable Single Judge has taken a sample from that. The whole figure in the entire examinations out of 42,000 from 12 lakhs.
12 lakhs was what?
Sorry, not 12 lakhs.
1 lakh 25.
Sorry, 1 lakh 25. Sorry.
Out of 42,000.
Sorry. Sorry. It was.
Once questions are put to you, you become temperament changes. Why, Mr. Dhar?
I shouldn't.
Such a you are not.
I repent.
We
I
will
repent.
pre-queue.
I repent.
We will pre-queue.
True.
So that you
No,
can.
I repent. I realized it. And
We have a right to do that
true.
because we are in the same.
No,
track.
because no, I don't know. By saying more sorry will not do.
It's always there. We were also on the other side of the.
And sometimes what happens,
No, don't tense yourself.
I
in that
understand,
manner.
true. But sometimes this process, what happens, my lord, may I say this? This is
You are-
30
Your-
seconds digression.
Huh?
30-second digressions.
That is
My
because
lord, no matter how much we put an effort, maybe we become expert also. Sometimes, maybe we also are so emotional being.
no.
Shouldn't. Yes, shouldn't.
Yes, page 238. You show us.
Yes. Page 238.
1,940.
May I just,
12,
my lord,
14%. Not 1,25,000 যেটা সেটা হচ্ছে টোটাল অ্যাপ্লিকেশন এই 5216 আউট অফ 42,929 সেখানে পার্সেন্টেজটা অনেক বেড়ে যাচ্ছে 12.14%.
No, your note says page out of 42,949. That was the appointed.
may I just, because Lordship need not enter into entire part of it. I am trying to say the perception of the Honorable Single Judge was huge. Now the huge should have some meaning in a perspective. In 42,000, 5,000 is about 12%. So meaning thereby 12% in the whole examinations, they were academically not so good. But verbally they are good. In fact, I found many of those 5,000, they are even more than 50%. I take the all figures without any deductions. And then in an examination, so what is the other perspective? 88%. Look at this. 88% in the entire examination, going by the facts and figures of the writ petitioners and the Honorable Single Judge, all were academically better.
Yes.
So therefore, the moment Lordship gets the picture that actually 88% are academically better, then to say it is huge is incorrect, because there are consistent judgment of the Honorable Supreme Court. Even not judgment, Lordship, I think this is a very common thing. We know many of us, I would say it may be more than 12%, we are able to speak, we are able to formulate, we are able to analyze, but academically we may not be good. So here only 12% of them, they are not academically that good. So 88% even academically good, even orally good.
Yes.
On that point, kindly take, my lord, this 2024 judgment. 2024. Seven SCC 262. Okay.
This was placed by Mr. Dotto, I think.
This-
24/7 SCC, Obhinit.
On this,
Anyway, you give us.
I will just touch upon it. Well, the paragraph that I would be relying on, that's I have quoted it. So till the time, my lord, that my copies come, may I just refer from that? So paragraph 87, my lord, this I was only that written test cannot possibly capture the full spectrum of the individual's abilities and potential. An interview can also provide a medium for marginalized candidates. Well, here comes that. In fact, that judgments that someone not knowing English, for marginalized candidates to showcase their talents in ways which a written test may not be possibly allowed. And 90, an interview unveils the essence of a candidate, their personality, passion, potential. These are very much, my lord, very much intangible, very difficult to find out. And then let's move to the next judgment. 2006, 6 SCC 395, paragraph 54. Very good. 2006, 6 SCC 395, paragraph 54.
Yes.
Kindly see paragraph 54. In our opinion, the interview is the best mode of assessing the suitability of a candidate for a particular position. While the written examination will testify the candidate's academic knowledge, the oral test alone can bring out or disclose his overall intellectual and personal qualities like alertness, resourcefulness, dependability, capacity for discussion, ability to take decisions. Let me kindly mark this. Here, the ability to teach naturally, qualities of leadership, etc., which are also essential for a judicial officer. This was in the context of a judicial officer. It has to be much, much higher, but the principle. Then paragraph 55. Well, paragraph 55, well, from page 420 in Placitum D. It is now well recognized that while a written examination assesses a candidate's knowledge and intellectual ability, an interview test is valuable to assess a candidate's overall intellectual and personal qualities. While a written examination has certain distinct advantage over the interview test, there are yet no written tests which can evaluate a candidate's initiative, alertness, resourcefulness, dependableness, cooperativeness, capacity for clear and logical presentation, effectiveness in discussion, effectiveness in meeting and dealing with others, adaptability, judgment, ability to make decision, ability to lead, intellectual and moral integrity. But thereafter, while we do feel that marks allotted for interview are on the high side, and it may be appropriate for the government to re-examine the question, we are unable to uphold the contention that it was not within the power of the government to provide such high marks for interview or that there was any arbitrary exercise of power. In this case, high marks is not the allegation. In this case, this is also not the allegation that huge, that means the opposite, that is the reverse, that 88% they are academically bad. So fact, which is not the perception, just the perspective is that 88% academically good, orally good. 12% academically not good. So therefore, based on this, to say huge, my humble submission before Lordships is only a perception, leaving the perspective of the matter. It is like saying 100% Eden Gardens, so it's Eden Gardens is full. Same thing. Kindly validate my next point. This is page 5. Well, there was an opposition filed in this same appeal. This was the AO by Priyanka Noshkar. That was also, that copy was also referred, part of the record, also referred by Mr. Anindra Mitro. If Lordship kindly take page 14 of that.
Page 14 of what?
This is
Page 14 of?
Page 14 of the AO filed by the writ petitioners in this appeal.
This appeal means 873.
Yes, 873.
873 is opposition. 873.
Well, as a backup, I have had that spiral separately, but this is part of the record.
Don't give us any further papers.
Yes, I also think that that should not. What about 14, 15? Ready?
AO by?
Yes. Well, this is
403.
No, page 14,
14
14.
of 873.
Page 14 of 873, but not the paper book itself. I am saying
No, paperwork, when
it is not part of the paper book. It was the part of the opposition filed to the stay application. And this was also seen by you, possibly in a spiral. কিসে আছে?
এমনি আছে
Separately.
দুটো ফাইলের একটা প্রিয়াঙ্কা নস্কর অ্যাকাউন্ট করে আছে
হ্যাঁ, it was affirmed by Priyanka Noshkar.
স্পাইরালে থাকবে না স্পাইরাল
It is not in spiral. কিসে আছে?
নরমাল আছে
এটা দেখি দাও।
নর্মাল মানে নট ইন স্পাইরাল ক্যানট বি ইন স্পাইরাল
ফাইল করা আছে
তোমাদের
না,
spiral?
এখানে একটা না এটা নয় এটা তো ওটাতে নেই এটা আনমার্ক
যেটা দিয়েছিলাম
এটা
Well, Mr. Mitro also had given this in a spiral, possibly for convenience.
এইটা
এইটা
yes, page
Page 14.
14 is the memo.
Or is it a
Page
letter?
14 or para 14.
Page 14. Lordship may take my spiral. No.
You won't be able to keep track, no? This is the problem. Affidavit in opposition of the respondent writ petitioners to the
প্রিয়াঙ্কা নস্কর
Priyanka Noshkar. Yes. Priyanka Noshkar. Well, there is a chart from page 15.
ইয়েস
Yeah, that is. I will be showing the chart itself. How the chart begins for that 14. But basically, my whole endeavor would be on chart.
yes,
Well, same document, Lordships might be required to see side by side. I have done my homework. Page 15 and page 20. So it may not be possible physically to keep it. Page 20 I have separately taken so that side by side Lordship may can see for same document. Page, this is page 20. Just keep it side so that Lordship will not have to go. Malab, this is the chart. What is the chart? That is there in page 14. Can you have a look at this? Writ petitioners breakup of their marks in their respective medium, category and district. Now kindly come 15. My lord, this 03, that's a code, that is Coach Bihar. Deepak Chaudhary is the writ petitioner number 37. He got 12.687. And from page 20, Lordship will see the last mark was 16.607 in his category. By saying his category means in Bengali, in district Coach Bihar, in unreserved, in OBCB.
that is for para teacher category.
No, Lordship is,
Page 20.
don't see page 20 now. I said 20 only for one purpose later on. Kindly see first page 15.
Yes,
Page 15,
12.6.
Deepak Chaudhary Lordship has got. Deepak,
12.6.
kindly mark Deepak Chaudhary is writ petitioner number 37. All our names are writ petitioners. I have marked who are at what number. So Deepak Chaudhary, petitioner number 37, belonging to Coach Bihar. 03 is Coach Bihar.
Hmm.
Subject is Bengali. Category is unreserved. OBCB. He obtained 12.687. And in his category, the last person obtained 16.607. That can be found from page 20.
Yes, from that, what we are to understand?
Let me give 3-4 examples. There are second 04, that is Uttar Dinajpur. Category is Bengali. Nimai Ghosh, petitioner number 121, unreserved OBCB. He got 13.606, whereas the last person who has been appointed, that person got 13.796. So that way, my lord, I have done my homework for each of the petitioners. And right hand side,
So you got 13.606 and
not me, writ petitioner.
Nimai Ghosh.
Yes,
Now
He
the
got-
last person in that category got
13.796.
that is more than 13.
Exactly, that's the reason he was not appointed. So that's the clarity, no corruption. The percept.
ক্যাটাগরিতে হচ্ছে ও 13.6
প্যারা টিচারটা কোথায় কোথায় কোনটা নিয়েছে প্যারা টিচারটা তাতেই বলে
বলছে 13.796 is the last person appointed in Tola AQ appointment finds district of
প্যারা টিচারটা কোথায়
The last person you are showing that is of Tomolika Kundu.
What has happened?
That is in the para teacher.
Exactly, and that is a separate category altogether.
Category. Yes. Very good. Now
There are hundreds of separate categories.
no, this is a mismatch which has not been gone into by the judge.
It is not a mismatch. It is an incorrectness in the understanding of the honorable judge by taking one figure of the para teacher and assuming that.
Where is that? He has taken one figure of the para
Kindly come to impugned order.
Yes. Which paragraph?
Yes, I'm coming. Kindly take paragraph 7. Paragraph 7.
Yes.
From the breakup, the petitioner found and alleged that the particulars given therein are absolutely false, as because the lowest number of impaneled candidates was shown in the report. This is the report as 14.191, whereas throughout West Bengal, 824 candidates who scored below 13 were appointed, and the petitioners prepared a tabular sheet of such and such. So 14.191 was obtained by a person in a category called para teacher. That was understood by the honorable.
No, 14.191 is teacher. Where do we get it, para teacher?
That page 21. Kindly take this page. It is there also, but Lordship has to.
This paragraph 7 refers to a tabular sheet which was produced.
This
Where
is
that tabular sheet.
Yeah, this is what Lordship is saying. Kindly take page 21, code number 19 from the bottom, second one.
Yes.
Kindly see the marking 14.191.
Yes.
Kindly see the category. Para teacher. And I have done each. Well, I have taken last night. I have asked my juniors because I needed 3 persons just to make this comparison. In each category, I found writ petitioners remain unsuccessful by getting lesser marks. The incorrectness is application of a marks of a para teacher irrespective of categories.
Yes.
Only I have done the full, but only for satisfaction of your lordships, 2-3 I can give. For an example, kindly take just as a random as code 05 1 2 3 4 fifth, not fifth, fourth one. Name is Sham Sundar Das. 05 means Dokhin Dinajpur. So in Dokhin Dinajpur, unreserved OBC A, he is a petitioner number 48. Sham Sundar is 48. Sham Sundar got 15.261, But in that category, the last person got 20.179. That's why Shamsundar did not get the job.
Where do we get it? 20?
20. Kindly come to page 20, serial number 3, right hand side. That's the category.
Shamsundar Das.
এটা হচ্ছে কাজী আলী। কাজী
There are two OBC, Shamsundar and Shabina. Shamsundar is petition number 48, Shabina is 49. Both in OBC A. Both got, one got 15, another 12. But last mark 20.179. Lordship may take the other example of 06, that is Malda. Malda Omar Singh is petition number 64. In fact, there are a good number of in this category. This category is Malda Unreserved SC. The last mark was 15.930. And look at their marks of the entire SC.
All right. Yes.
What the Honorable Single Judge has done, Honorable Single Judge has picked up the category from para teacher
And tallied it with the
Yes.
other teachers.
and the advertisement is at page 120. I was not able to read it. 120 of the paper book. Lordship will also not be able to read it. But I have, to the Zumbo Xerox, I have done it. One page has come to 11 pages, but it is nicely readable. This is the advertisement. It gives a so clear look of the variety of categories there. Now this is the same page, only Xeroxed so that it can be readable. This is page 120 of the paper book.
Yes.
These categories from third page. Lordship will see all the code. Like Alipurduar is a code 02. Code is not there, here district is there. Bakura is 16. But categories Lordship will understand from these boxes. Only for that purpose. So therefore, well, I have checked up myself of each of the categories, and there are 4 areas. Even there are no vacancies because all were filled up by the trained. Because first has to be trained, leftover it goes to the untrained, not otherwise. Now, I myself have taken note of all. If Lordships want, I can give one page of, and I have found each of the petitioners of 139. Each one of them, they have got lesser marks than the last candidate in that category, which was there. The mistake was picking up the category of the para teacher and spreading over to all.
Yes.
Well, there is a one point I will not say anything because these are the points anybody appearing in the service matters. But I have taken note of. Lordship may refer it, but I will not consume any time for that. My point number 5. I said that having participated in the selection process, being unsuccessful, writ petition is not maintainable, particularly when filed after a lapse of 4 years 7 months from expiry of the panel and 5 years 4 months from approval of the panel.
When was the appointment made? When it was in 2000?
In February, March 17. That is the one of the window conditions that I said.
February to March.
February, March 2017. And writ petition was filed.
September 20.
Yes, September 22.
Yes.
Well, there are 4 judgments. I am not placing that having participated after so many years. Paragraphs are also there. I am not saying anything on that. Now, my lord, my submission is kindly take my lord 165. Kindly
It has
take
been
this.
argued this.
No, I know, but this has not been. I will not. This has not been. What I'm going to say, this has not been. Most likely, Lordship will see this is new.
Yes.
May I just, my lord, formulate? I will not take much time on that. 1932, there is a judgment saying on 165 that 165 cannot be used in contravention of any of the provisions of the Evidence Act. That's the parameters. Now I find there is a definition of the judge court in the Evidence Act, and under 165 it is the power of the court to put question as opposed to call somebody, and it is in contravention of 137 because 137 clarifies who that. Kindly have a look at just three sections. First 165
Evidence Act to the
evidence. Like this is 20 page 51. Well, section 3 defines the court. Sorry.
Yes.
Section 3, the definition clause court. It includes all judges, magistrates and all persons except arbitrators legally authorized to take evidence. Now kindly come to 165. Kindly see the very beginning of it. Judges' power to put questions. Power to put question is one thing. Power to call, which is controlled by 137, is a different thing.
Yes.
So, judges' power to put questions or order production. The judge may, in order to discover or obtain proper proof of relevant facts, ask any question he pleases in any form at any time of any witness. Rest need not be read. So, I completely agree with the power to put question to a witness. Kindly come to 137.
Yes.
137. The examination of a witness, kindly mark thereafter, by the party. Cross-examination, the examination of a witness by the adverse party. The court is defined under 3. All I am saying, first under 165, power to put question as opposed to call. Next is to who? To a witness. Who is a witness? 137. Two kinds of, by the party or by the adverse party. The whole code, having defined court under 3, not including court there under 137.
Yes.
And maybe that is the reason we were finding so difficult to get any judgment that the Honorable High Court, having exercised 165, has...
Sir, are you suggesting that a court can't call its own witness?
Court can't?
Call a witness.
My lord, if Lordship goes by this 137...
137 is restricted to a party calling a witness.
Yes.
But that does not mean that the court can't call for a witness. There is the issue of subpoena.
Yes.
Subpoena is when the court calls for a witness.
Can, but court is calling a witness. But who is the witness?
Anybody.
Now, I say that witness has to be by either of the parties.
That's 137.
137, this party.
But there is a provision for subpoena.
Yes, there is.
Can subpoena a
Yes,
person to
there is.
Why shouldn't 165 be covered by that?
That's a possible view. It's a possible view, and it's a liberal view. We should tilt towards liberal, but I would say, in the context of this case, to call specific number of persons or to choose, that doesn't come under 137. There are other points, but I'm not disputing your lordships. Lordship has taken a very fundamental point. I do not want also that the court be denuded of, I don't want, but here and there, little bit of change of context makes a lot of differences. The first step is whether the court can at all exercise 165 in a writ proceedings. That's the first.
Separate issue.
Yes. If the answer is yes, is it in a...
Apropos your argument that 165 presupposes a witness being there, and only then the court can put questions. Apropos that,
Yes.
the court can always summon a witness
Can.
by way of a subpoena.
I understand. Can. I can't.
And 165 will...
Can. But my submission before your lordship would be, since these codes are more often a very, they are in a very watertight way. So there, and I don't find the word code anywhere in 137 there. Yes, subpoena, agreed. But there is a judgment 1932. Just a second. This one?
Yes, what is your...
Yes.
30
This judgment, sorry.
1930.
Yes, 30. That Rahi Jaddi, 1930 SCC Online, Calcutta. Kindly take. There is, I won't be able to say paragraph, but I can take your lordships too. But there is a very light marking, page 1012. Lordship, kindly come to bottom. Second page. 1012. Oh, watch. 191.
Yes.
Kindly take, my lord, second page. On the second page, my lord, somewhere on the top, there is a page 1011.
Yes.
And thereafter, there is 1012, a little above 1012. The judge may ask, well, this is, I quote from Amir Ali and Wood offers law of evidence. The judge may ask any question in any form and at any stage of the case, and to a certain extent even allow parties or the advocates to do so. This, however, does not mean that he can receive illegal evidence at pleasure. For if such be left to the jury, a new trial may be granted even though the evidence were extracted by questions put from the bench. But it is a power necessary to prevent justice being defeated by technicality to secure indicative evidence, and in criminal cases to assist in fixing the amount of punishment. In the present case, the alleged statements before the police were not properly put in evidence under section 162 of the Code of Criminal Procedure. They are not even proved as substantive evidence. Yet the learned judge made use of them in order to discredit the witness, insofar as he did not support the prosecution case. This he was not entitled to do. I am supported in this case by the case of such and such, where in similar circumstances it was pointed out that Section 2 of the Evidence Act left the provisions of Criminal Procedure Code unaffected, and it was held that, but this part I am relying, power conferred on a judge under section 165 of the Evidence Act could not be exercised for the purpose of introducing evidence in contravention of the law. In that case, it was 162. Here I am trying to say it is 137. But there is the next judgment is 2013 4 SCC 465. Paragraph 24 and 30.
This has been argued, Mr.
Then I'm not stressing. I'm just
This has
giving.
been argued.
Can you take this? There are 4 citations. Other was 1957 SCC online SC 30 paragraph 10. But I have quoted also paragraph, so I'm not taking any time for that. And there is a 75 judgment, 75 2 SCC 557 para 21, 23, 24. There paragraph 21 was on the judicial review and vis-a-vis whether it can be used. And the 2011 10 SCC 249 paragraph 12 and paragraph 13. This is a very settled proposition. And 2019, this is a single bench, so I'm not relying on it. Let me leave that. Kobita need not be. And that Ajay Singh, my lord, that is also this too. Roman 4 and 5, I'm not relying. At the time of preparation, I thought, but on a second look, I thought may not be. Plus, the other
to that 1110 SCC.
Yes, paragraph 12 and 13.
No, 13. What does it say? In 226 what? That was
So
a case of,
it was not fully there. May I just?
that was a case of disciplinary proceeding.
Yes.
What you wanted to say by paragraph 13?
May I come there? Page 7. Well, 13 was, Lordship has read that. Well, there, Lordship has seen the evidence.
No, Mr. Dhar, there is no bar of exercise of 165 and in 220.
Nobody is saying. I have also
an argument which was advanced was the primary argument, judge cannot act as the prosecutor.
The judge cannot
act as the prosecutor. It was the argument that his lordship himself has put the question without giving opportunity to the person who would be affected by that from cross-examining him. That opportunity was not granted, so you cannot look into that. But in 226, facts and circumstances, 165 can be taken recourse of. Do you have any judgment against that? That in 226 it cannot be done?
My only judgment is this cannot be in contravention of another provision of the Evidence Act.
Again, you are falling back on.
But I have.
There is no pat on the point judgment.
I have searched. There are two things. I have not been able to see a judgment accepting the Honorable Single Judge's this judgment where the Honorable Single Judge has exercised 165. So there is an absence of a proposition of law, meaning thereby, I'm not saying this is correct or wrong. All I'm trying to say, so therefore the constitutional courts possibly thought not to use 165 in usual circumstances. That's why we don't find, because we have searched so much. So there are not number of judgments saying in case of X it can be used or in case of Y it cannot be used. It's a vacuum area minus.
we are discussing. No judgment has been shown to us that there can be no application of 165 in 226%. Now, there are spelled out parameters that in A, B, C, D conditions, if arise, just the learned judge has proceeded on the basis there was a large scale corruption. There was a scam.
Correct.
Jobs were sold.
Correct.
So, is that the issue on the basis of which His Lordship exercises 165? That also you cannot totally rule out. It is the perception of the judge.
It is the perception of the judge.
That which you argued that the perspective ought
Yes.
to have been ascertained
Yes,
before
yes,
that.
What I felt, my lord, this is my genuine feeling as a counsel.
Mr.
While
Mitro's
prepared-
argument was that on the rudiments of illegalities and irregularities, you cannot establish a case by exercising 165 that there was a corruption. Corruption has a certain extra amount of element,
Yes.
which is different from the mere illegalities and irregularities.
Yes. Yes.
So that may have been a ground.
True.
We expected that may have been a ground, but in the judgment,
That is
why does His Lordship go to that effect? This predisposition which was being urged by Mr. Dotto on the first day. Now, from the judgment, paragraph 17 to 22, His Lordship proceeds on the basis that I need not go into the judgments.
Yes.
They are poor persons, they are jobless.
yes.
So I take up the role
Yes.
and I ascertain that yes, there was oil.
Yes.
So is there any judgment to that effect that these are the described parameters on which 165 could have been applied?
I have
No
not.
argument.
I have, in fact, I have asked all my juniors because this is
So no, then what is your answer to that? What according to you?
my
What according
Yes.
to you? Why will a constitutional court
should.
is going to that point? Why?
Now, there are, if I would say, allow me to say this, law and justice is a living thing which grows. So, as a part of the institution, most likely I will not, I'm saying very subjectively here, I will not make any attempt which goes contrary to this living nature of law and justice. Meaning thereby, what was Article 21 50 years before and what is Article 21 today, there has been a change. For an example, there was a time the conception had been that as if Constitution is providing these rights. But the change is that no, by natural law as a Homo sapiens, there are certain things which cannot be alienated from you. Constitution is only recognizing. It's not a source of birth of your rights. For an example, someone is thinking. That is not that Constitution is giving. So it is constantly changing. Keeping in mind the change and the living nature, I would say that today, in the present context, I don't think we have arisen at a stage where Lordship are required to frame up parameters that under these circumstances 165 can be utilized.
Yes. All right.
My lord, then if I can just add two more sentences on that, what I feel is if the perception gets changed, for an example, if the context becomes clear in a proper perspective, that actually it was in a para-teacher, which is a separate category, then my lord, anybody, even the learned judge would have thought otherwise. So maybe the perception, connecting all these perceptions, starting from the aptitude assessment, vis-a-vis a separate test, and this marking, all connected, one may have a perception that there is a corruption. But when Lordships today is seeing it in a different perspective with all the facts and figures before your Lordships, there may not be any requirement at all to frame up parameters for that. If Lordship finds that this is a case where if there are necessity, no doubt, but my respectful submission that possibly this is not such case. This is not such case where the Lordship would be requiring to frame up parameters under which there is a requirement of the High Court to enter into 165.
Mr. Dhar, there is a nobody has addressed us on the issue that suppose the state 2014, state 2012 primary teacher appointment, you find a nagging indication to the effect that
True.
there has been transference of money, there had been a money trail, there had been a scam, there had been arrests, but nobody of you have argued this, that where does that link us? Suppose in education, in education, suppose there are 5 consecutive investigations going on.
Correct.
One upper primary, one primary,
Correct.
one lower primary, whatever it is.
Correct.
So, as constitutional court is looking into the matter in the backdrop of the corrupt procedures which has seeped inside our education system.
Correct.
But nobody has argued us that suppose you conduct an examination.
Yes.
My brother and myself are participants in that.
Yes.
You realize after the examination that there were 1 lakh candidates and there was a large scale corruption or scam, whatever you
True.
describe.
True. True.
But if I am there, you have to link me with that corruption. Then the analogy comes of the illegal beneficiaries or the persons who have illegally, suppose a person has given a certain amount of money to certain person and on the backdrop of that he has got the appointment. But it is, how do you establish it?
May I say this?
One is that there is direct evidence linking me to that offense.
Yes.
That yes, I have given bribe.
Yes.
And the another is the perspective which you are arguing.
Yes.
You have repeatedly said that don't apply the perception to the perspective.
Correct.
But what more can be done? The perspective is all round corruption and scam. Then as a responsible citizen, how do you argue?
May I argue?
My lord, kindly do not drag me into that illegality because there is no evidence connected.
I understand. I understand. May I say? I have understood, my
So
lord.
this is the soul of the court.
Yes.
Constitutional court
True.
is seeing that 5 stages where corruption is there.
True.
Investigation is going on. CBI, CID has come into the picture.
True. May I?
So,
Yeah,
the-
well,
how do you suppose you were in the seat of a judge?
Yes. How I would be responding?
That's your perception. That's your perception.
Has to
The
be.
division court may not apply that person because we are independent human
Correct.
beings.
Correct. Correct.
What is wrong to you may not be wrong to me.
Absolutely.
But you cannot just cull yourself out from the regards of this perception which has led to the delivery of this judgment.
Well, may I say this? I have understood. Now, this part of the submission is not as a counsel.
But
It is-
nobody has argued before us.
No,
Still,
no.
this is the
Well, I have
7th
understood.
hearing.
I have understood.
Nobody has argued.
I'm a-
Nobody has argued that there is not a scrap of paper to establish that I had given bribe to obtain the appointment.
May I say this? May I say this? Well, this part of the argument submission has got nothing to do with appearing as a.
No, that is on the no, Mr. Bandyopadhyay. It has been argued what? That Mr. Datta has proceeded on the definition of corruption. That what is corruption?
On
in
facts
the
and figures, like you did.
Just hypothetically imagine a situation. No. Why we have said hypothetically you imagine a situation. Today an investigation is going on. Tomorrow say the investigation attains finality and it is found that the person who have taken there is direct evidence and they are guilty of this thing.
May I?
On the perspective that there is a criminal investigation will entertain, despite the investigation having no legal right, and court will not examine because this is a writ court, not as a PIL court.
Court has it is not a you are going into you are not independently viewing the matter. The answer which we are wanting.
ওই জায়গাটাই বলতে চাইছিলাম যে একটা ছোট্ট একটা লাইনে বলতে
From the aftermath of the case, 2014 the case, the recruitment process of 2016.
May I?
That we have.
I have. This part has got nothing to do with my clients. Me as a counsel, I'm saying, because whatever I think. Well, I'm continuing where Lordship ended. in the entire environment, when the entire environment is polluted, what to do? That's precisely. We have now the perspective of 26,000 gone. I'm saying the
No, we
SSC
are not
case.
concerned.
I'm saying the other. So the environment. So far as this case is concerned, there is a reference of the word CBI investigation. Lordships are aware that every recruitment processes are separate. Like I have to pass state. Assume I have passed state in 2014. Does not mean I will only participate in 2014 or 15 recruitment. Once I am TET passed, it's a prerequisite. Then I can participate in any.
Kalyan
Yes, Mr. Bandyopadhyay has said. So what I'm trying to say, in the end,
stepping stone.
in the end,
Apply that TET only, not only for this. The training qualification will remain with the TET eligibility criteria.
yes,
Specifies 15 marks in a selection process, as in this case.
yes. No, what I'm saying is that so far as any allegations of the TET, Lordship will not find anything, any paragraph being dedicated anywhere in the judgment, not in the writ petitions, nowhere. Today, before your Lordship, I could have understood, but there are situations where Lordships have to enter into, and there are situations where Lordships are not required to enter into. In my humble understanding, Lordships are not required into the environment aspect of, as Lordship was expressing, I'm saying metaphorically, based on the writ petitions, affidavits, pleadings. This is a case.
You leave it untouched.
Yes. Why? Well, I say why. There is a reason for that. Why? Reason being, in the entire writ petition, Lordship will not find enough materials.
Yes, that you have, that has
And-
been shown to us.
And only tilting factor, I could have understood that Lordship feels that every part of the evidence, every part of the marking, whatever learned single judge has said, that is correct. But there is a likelihood that Lordship may feel that that was a perception of the honorable single judge. Huge, as I said. The marking taking from the para teacher. So therefore, if Lordship picks up 4 or 5 points of the entire judgment, Lordship will find each of the judgments actually false. Sorry, each of the logic in the judgment actually false. It doesn't stand. It can only stand if someone looks at the issue based on an incorrect facts. For an example, if truly the para teacher that marks had been the last marks for everyone, then learned judge is right. For an example, this 12%, if it is found to be something for the first time, any examination this has happened, then in every examination out of 100 persons, 100 of them should be academically better. But this is not. So,
All right, thank you, Mr. Sir.
but there is a portion, this part I will not make any submission. Point number 7. Only because but I'm relying on this, my lord, the judgments I have given on the point that when they are filing after 4 years, 5 years,
They ought to have made us a part.
so the necessary party I have given the judgments, why it should be dismissed. I'm not reading out. The citations for my learned friends, it is AIR 1963 SC 786 paragraph 9 and the 2014 16 SCC 187 paragraph 4 where ought to have been dismissed that point, and then followed also in 2022 SCC online SC 1307 14 16 SCC 187 paragraph 4 22 SCC online SC 1307, and I just added rule 12, the validity of the panel 1 year, thereafter 6 months, then 6 months. So I was trying to look at from the perspective of the writ petitioners that yes, it is a case which has been filed during the validity of the
On the validity of the Panel was not even published.
Well, there is no requirement of publishing in
So
law. Doesn't require
how come
it.
you take this point? There is no definition of publishing.
It was on the website. It was all
But the definition.
all these documents, all these markings, they have obtained. All the calculations of 14 marks and everything, all they have obtained from the website itself.
No. Your content, their contention had been there was no publication of the panel. If that.
They are absolutely right. There was no publication of the panel in a sense that the entire panel being published, but the names of the candidates with the breakup marks who have been successful, all were put on the website.
No, that is subsequently. That is subsequent to the writ petition, na? As called for
My lord, I will
by the
answer to
court.
Mr. Dhar, my lord. Your lordship, kindly, my lord, give me permission, my lord. I will answer to my learned senior friend, my lord.
You
So
take
far, your
note of
lordship.
that. You
Yes,
take
yes, I have
note of
taken.
that. We will be asking you.
Well,
to
on a pure point of law, Lordship will not find.
kindly come to the definition of panel.
Well,
Panel definition means a list of names of eligible and selected candidates for appointment as teacher in primary school published by the board. And Nihar Ranjan বিশ্বাস, you are good in front of me.
Yes, my lord.
But this publication,
Oh, that.
publication, wait,
Well, what is
so the word publish is not there under the rules. But that has been drawn by them. They have argued that you see this definition, so publication is mandatory, which is publication issue was not there.
True.
Now the board's counter statement was that everything breakup and everything the single
Yes.
judge has called for.
my contention is only this.
Yes.
No one is perfect. We learn, rectify, move on. There are certain things which cannot be rectified and that has to go. No one is perfect. Assume
Taking the ground that you have come after 5 years.
I have taken that ground.
You have taken that.
Yes.
Ground. I am a participant.
Like nowadays, all
I participate.
yes.
I don't get a published panel. So
He-
what will I do?
May I say this? Then I would say that person is absolutely unintelligent. He doesn't deserve to become a teacher because
That is because you have no answer for that. That
no,
is
no, not for that. Someone having after participating, he will simply go for a hibernation. He will sleep.
Yes.
Well, even today, Lordship will see, we get all the orders from the Honorable High Courts.
So you mean to say it was their obligation?
I say this, may I say this?
It is not the obligation.
I say that one thing in a different angle can look something different. I say that there is a gradual improvement in the entire process. Like today in every selection process, they are trying to be more transparent. But there was a time when there might have been some, I do say, it was not as perfect that as required to be, in a sense that every part of it has to be transparent. But this is a process, my lord, going on. Now, once informations were taken by the Honorable Court, and it was also thereafter put on the website, when that is checked up, and that is found to be in order, there, after 5 years, because lordships are also, when writ petitioners have come, absolutely fine. But simultaneously, the other side, kindly take an example of this. I know this is nothing to do with law. Because I got that job in 2017, because the same honorable judge also passed another order, whoever has got the job in 2017, this recruitment process, they will not be able to participate in further recruitment processes. And the board acted that. So once I got the job, I am working, I am surviving, my family is surviving, I am not able to participate in other recruitment process. 4 years have gone. Now to look back would be too much of things required. All I'm trying to say. I don't say absolutely big no, but their requirement has to be so many things which are absent in the writ petitions or the pleadings or in the basic facts of the Honorable Single Judge.
Yes. So that is what Mr. Mitro was saying, no? That if today they have only, if you give them the job, they will not challenge our appointment.
Because justice, my lord, what I find is justice is quite a nuanced thing. Just by termination of persons, it may look as a justice. It may look, I'm saying, because we don't live in utopia. So amount of the irregularity and corresponding whatever directions will ultimately be the very.
So for generations, persons will be taught by persons who are not competent for that thing.
Well,
This is not a specific performance.
that formation based on fact that we are not competent has to be arrived. All I'm trying to say that the system is not perfect. I agree with that. But we deserve the system as we are. We are also not perfect. But that does not mean we are incompetent.
Yeah, that is because the learned single judge reverts back the selection to the same body.
That
Without earmarking that what should be the parameters of aptitude.
now
Then the same mistake will go on for generations.
yes,
Same mistake
yes,
will
same
go on.
mistake.
But Mr. Dhar, you cannot say, suppose you are arguing on your side, I have worked, I am in service, I will not get job. But what happens in the greater interest of justice?
Malak, choice is not between good and bad.
How the society suffers then?
Malak, choice is not between the lordship. I don't think it's not between the good and bad. Accepting the environment being such, choice between bad and lesser bad. My submission before lordship would be lesser bad would be setting aside of the judgment and order of the honorable senior. That is my submission. I don't try to say that every part of it perfect. When lordship opens up and says yes, that is there, but lordships are really not having the choices between good and bad, because system would go on. Lordship, for an example, this transparency, there can be transparency in future, but the fundamentals of saying this to be not right, those fundamentals are mostly colored by the perception of the honorable single judge.
Thank you.
And on the validity of the panel, there are 2010 6 SSC 777, the paragraph 16, 24, 25. Now, no relief cannot be given based on Kaushik judgment, paragraph 28 also. Even today, if relief has to be given, then that 28 has to go. 2010 6 SSC 777, paragraph 16, 24, 25. And I'm not placing it. This is already I have put in my notes. And then 24.
No legal right after panel expiry. Panel was not published.
Panel was approved. Publication of
Board.
by the board. And thereafter appointments were given. And then the panel has a life of 1 year.
All right.
And 6 months.
Was
Rule 12.
Rule?
Under Rule 12,
Uh,
the panel validity is for 1 year, thereafter 6 months, then 6 months. I say that you have participated, so you know that the validity is 1 year, 6 months, then 6 months, so 2 years. So within that 2 years you did not come.
Rule 12.
Yes, Rule 12.
An approved panel. Yes. That
Kindly see first
approval
nine.
of panel was brought by them. Approval of panel documentation was there. That they
Well,
did.
Kindly see 9. The panels after being prepared shall be accorded approval by the board and thereafter shall be sent to the respective district and school council with all necessary papers for appointment. So that happened pre-February 17. And then kindly come to 12. An approved panel shall remain valid normally for 1 year from the date of approval by the board, provided that the board may extend the validity of such period panel by 6 months at a time, but the total period of such extension shall not exceed for a period of 1 year. So I take it so 1 year, and then also I take it further 1 year. So 2 years.
So the when was the approval given?
That was, I believe, before February 17.
February.
Before 7, it could.
Appointment was in.
Appointment was in February, March.
So we can take it as February.
I take it that's why. So February 17, if Lordship adds 2 years by then, my lord, I get the benefit of this judgment. 2010 6 SSC 777, and then There is a latest also 2024 SCC online SC 1189, paragraph 10 and 30.
Yes.
And there is one more also on this point, 1996 9 SCC 309.
Please, Mr. Dhar, we would request you to on the judgments,
Compilation.
like in 165 you said na that all right, I'm relying on these two judgments. Only the judgments which are relying upon,
Yes.
if you can point out, because your note contains
No, well, only. No, I have understood. Lordship, may pen through here and now I can say. Well, in 165, only one judgment called Kobita.
160.
165, page 7. Can you come my note? Lordship, may put a cross on that. Page 7, Roman 4 and Roman 5.
Kavita Sharma.
Yes, Kobita and Ajoy. These two, Lordship may delete.
Others you have given?
Others, yes, all I have given.
No, all has not been.
No, sorry.
No, can you do this? The judgments, we are giving you back the judgments.
I can prepare a compilation.
Yes.
I would be happy to do that. I shall use. Oh, that's the reason.
All right, these are the judgments here. Yes, thank you.
And well, there is just kindly give me 1 second.
30. I got it. Okay.
This is my well, there was a
Chatterjee সাথে ইস্যু করে বসছে।
ওটা দেখে সিঙ্গেল বেঞ্চ বসে নাই
না, বাট পাবলিশ ঠিক আছে, ওরা কাটি নাই।
টুপি হচ্ছে Yes, what you are saying?
Well, there is in course of proceedings, Lordships asked one question, that why they did not challenge an interim order. Lordship may kindly remember that one of the orders by which some persons.
Yes.
Why? So I was trying to find out how to defend that part of it, because no answer came from this side. Fortunately, I could get a direct page 11 of my note, paragraph 15. There is a direct judgment 2009 3 SCC 250.
Paragraph 15.
No, not para. I said
That is your
my serial. Page 11, 15. This is 2009. That interim order not challenge is no consequence. Lordship, paragraph 28. Lordship, I have exactly quoted, because I was thinking how to. And well, no pleadings, no prayer, no relief. There are two, like everyone knows these two judgments, VK Majorta and this Ajoy Dogra, 2003 8 SCC 40, paragraph 8. And 2003 8 40, 8 SCC 40. Should I give the compilation afresh?
No,
or
not required. If we find any judgments missing, we shall.
Yes. I have all. This
you have given. Your junior has.
Yes.
What he has given, he knows.
There are. It is so voluminous. All of us, we are trying to get hold of all the points which can save us. So And 2003 8 SCC 40, and then 2011 14 SCC 243. I'm relying on that, but I'm not reading it.
All right.
But my serial number 13, they entirely relied. There is scope of reliance of RTI document. There, one judgment. What has happened? What they have relied on. Firstly, it was wrong, incorrect. Secondly, they have annexed couple of documents, which is their understanding based on their RTI replies. They have not annexed the RTI replies. They have only given some compilation trying to say.
So don't let them advance the argument. If required, you point
No,
it out.
only I'm saying that there is a judgment so that they can take note of that. 2021 19 SCC 396. Their High Court was not justified and had fallen into error relying on the RTI reply. In this case, our case is even better. It was not even an RTI reply. It was a compilation of RTI based on their understanding of it. Well, I shall be ending with 7th of July 2023 order, page 696.
What is this fresh selection part was set aside? What is that?
Well, I'm confirmed. This is, Lordship is hearing this because of the order of the Honorable Supreme Court, where I only want your Lordship's attention to be drawn on two things. One, prima facie, the Honorable Supreme Court was satisfied because of we are not even party. This part. Other part is, whoever is aggrieved, who challenges the order, not whoever is sailing in the same boat of the writ petitioner, they can challenge it and all contentions can be taken before your Lordships. Lordship may kindly have a look at page 703.
That has been shown to us by Mr. Bandyopadhyay.
Then I don't need to.
That the persons who are wanting to challenge them can come and say.
Phrase selection part was set aside because the Honorable Single Judge directed
That you hold the fresh
Yes,
selection.
yes,
That was
yes.
that
No,
was
first 3 months time so that they can do the training.
yes.
And then fresh selection, because now no untrained, because now the law is completely changed.
Now court said that no fresh selection should be done.
Yes,
Second part was also stayed.
yes,
It was not set aside.
no, it was
7th of July order.
yes, Lordship is right. Lordship is right. It was state.
Now why you have said fresh selection part was set aside, this bold in bold.
My reasoning is this, that the Honorable Supreme Court were fundamentally satisfied that these persons for 5 years who were working, they needed to be a parties.
Yes.
So therefore, whatever happened, good, bad, immaterial, they were not there. Like we are not there. Like today we are interpreting how the evidence went, but we are not there. We did not even get any chance to examine, to cross-examine. When the Honorable Supreme Court gave us a chance for which we are surviving today, only that part. These are my, deeply obliged.
How many?
আছে দেখো না একটু
They have not finished. They have not yet finished.
Only one more. I have one sentence. Nothing on merit. I am appearing for in this matter, but there are some visually challenged persons. So there was a request also by them. I am adopting. There is an application filed by the visually. All are visually challenged, and they are serving for 5 years.
Give us those appeal numbers.
Yes,
in which you are appealing.
Only reason that since I keep appearing for the visually challenged persons, I know them, their difficulties and every part of that. So for them, getting a job is something so big. So only adopting all the submissions I have made.
What is the number of
Yes,
that?
number is
CAN 58.
CAN 58 of 25.
Uh-huh.
Can 58.
Appeal.
Same appeal. In 873.
So that can is for what?
Can for addition of party.
That has been allowed.
No, that has not been allowed. It was none of these cans have not been allowed. I make only these submissions.
In any other appeal, visually handicapped are involved. In any other
In
appeal, 44
in my 635, I believe there is one person who is visually challenged. Only to draw your lordship's attentions that our world.
Can will be, we are hearing everybody.
Yes.
Can will be at this stage. If visually handicapped is represented by you in this appeal also, there is a candidate.
Yes. In fact, only one thing I can say from my own experience, there was a time when government never allowed any visually challenged persons to take any job. So it is our court in a public interest litigations. I remember first time when I met them, I wanted to know how you teach. You convince me.
That is can 58 or 2020?
5.
In any case, they are protected.
For them, for
অ্যাপয়েন্টমেন্ট যা হয়েছিল তার থেকে ভ্যাকেন্সি বেশি অনেক বেশি ইন এনি কেসে সিলেকশন পুরোটা ক্যান্সেল হয়ে গেল কিনা
only thing for them leaving home and to reach school, that itself something possibly we cannot think of that they have to go through. Only to I know
How many handicapped persons are there?
There are 7, but I want your lordships to take note of all.
So this 32,000 includes physically handicapped also.
Yes.
But in any case, they are protected. And why I am submitting so much? Actual vacancy of the physically handicapped. For example, it was 100 vacancy. Only 30 physically handicapped persons were appointed. In any case, they are protected, madam. That's my understanding.
No, this 32,000 was 36 was changed only or mentioning
Yes,
only.
madam. Yes, madam. Why? Numbers were not clear. Even today, the numbers is not clear. 42,000 and odd. Out of them, 11,000 and odd were trained. Rest were untrained. Why I differentiate between trained and untrained? There is a reason, madam. Aptitude test, for example, ask trained candidate.
No. Suppose, do you understand the 36,000 to 32,000? What happens to those 4,000?
4,000.
Today I am satisfied. I have not been sent out. Tomorrow morning I find my job has got.
Main crux of the matter was untrained, madam. Crux was trained and untrained.
Everybody is trained and
When it was trained and untrained, what happened, madam? There are two categories. One trained and another untrained. For example, if a trained candidate, even if he gets 0 in Viva and aptitude test, he would have been appointed. For training, the marks was 15.
No, we are not on the trained portion. We are only
Untrained portion. Yes, we are on the untrained portion.
That 15 marks goes.
15 marks goes. For there are roughly 32,000 candidates in the untrained category. That was principle. I filed the application, filed a petition, and subsequent application, subsequent documents were filed in respect of those candidates. In my writ petition, my lord, I have categorically stated what are the problems, what are the issues. Subsequently, and a question came to why I didn't raise the question of aptitude test at the time of filing writ petition. The problem is that on September 2022, writ petition was filed. For the first time, one breakup of score of empanel candidate came in the light on 28 November 2022, much after filing of the writ petition. I came to know that a number has.
That is how you explained your delay.
Another thing is there, my lord. The one thing, submission is being made.
We will hear.
A submission is being made regarding panel expired in 2018, but from the document filed before in this matter, appearing in the paper book 1, I can show the appointments were made in 2020, even from this particular recruitment process. That is on record. There are 11 additional panels, and out of how 11 additional panels were made, no one knows.
That is the subject matter of challenge. Then anyway,
No.
Mr. Putin Bhattacharya,
first limb of argument was the trial court has proceeded on a wrong premise that we are untrained. Because of the advertisement requirement of the advertisement and the statutory notification. Within 2 years, one has to be trained, which we have completed. Therefore, that is the first argument that the learned trial court has proceeded on a wrong premise.
No. You are untrained. But upon appointment, you have completed the period as prescribed under.
Correct. Absolutely.
That was your argument.
That's right. And that has been permitted. That is permitted under the statute.
And if I was
No,
appointed, I
that
would
point
have
has
gotten-
not been. I don't know whether they will take that point. The 6-3 application and your appointment and completion, that is not disputed.
Not disputed, but the learned trial court has proceeded that we are treating as untrained, ignoring that notification. That's why I am telling you.
They themselves have said that.
No.
you are
It-
coming on that.
Anyway, reply, I will get chance. I will show.
I shall satisfy your lordship.
I will, in reply, I will get chance. I'll show.
Board in their obituary.
On Friday, hopefully, you will be concluding your part. We have
But in any event, I have prepared a one-page note along with 3 judgments. I will not be taking more than 15 minutes of my time. Sir, I don't want to make any repetition.
if he takes 15 minutes, you are half an hour, we can conclude. The thing we are not being able to tell you is that let their arguments come so that I can seek answers. We can seek answers from it. Unless no, not 1 or 2 days.
I will be taking 15 minutes.
So we thought Mr. Dhar would complete it within 1 hour. We thought Mr. Dhar would complete, but he also has to make his submissions. This way the time goes. So we are requesting.